Hi all, I am Shankar Ganesh Rajendran, Advocate from Coimbatore District Court. Today, I would like to discuss upon what are the stages that a civil suit undergoes during the law proceedings. The first stage of every civil suit starts with a plaint. The plaint is filed by a person called as a plaintiff. The plaintiff seeks some kind of a remedy under law for which he files something called as a plaint. It contains of certain recitals in the form of claims, and in order to substantiate the claim, he files certain materials which are called as evidences in support of the plaint. Once the plaint is filed, the next stage of plaint is subsequently, after the plaint is filed by the plaintiff, the claim of the plaintiff is as against the defendant. The defendant is expected to file a statement called as a written statement defending the claims of the plaintiff, and to substantiate said defense, he files certain documents in order to defend the claim of the plaintiff. There could be certain documents, or in some chances there could never be any document to substantiate the claim or to defend the claim of the plaintiff. And to file a written statement, the time period which is statute by the law is 90 days. In case if there are certain exigencies or certain emergencies where the defendant prays more time, it could be extended for another 30 days by law. So the total time period for filing a written statement is 120 days. Subsequently, after filing the written statement, it is for the court or even for the counsel, for the plaintiff, to file the draft issues. What could be the issue arising in this particular dispute, which will be very brief in just one sentence. Whether, for example, an issue could be in the form of whether the plaintiff is entitled to the claim as prayed for, could be one issue framed. Whether the plaintiff is entitled to any sort of a remuneration or a compensation or any sort of a recovery as prayed for, could be one another issue. These are all just an example of issues. So once the issues are framed, the court decides that this is the issue that I'm going to talk about and to resolve it. Once the issues are framed, the next stage of issues subsequently is called as an evidence stage. During the evidence stage, the plaintiff is, in order to support his claim, as annexed the documents along with the plaint, has to be marked. During the marking of documents, the plaintiff is also expected to file a proof affidavit mentioning the claim of the plaintiff, as well as conducively undertake the recitals of the written statement and mention or substantiate that the defendant does not have any right of defending the claim of the plaintiff, as well as the case of the plaintiff is the prima facie case. In order to substantiate the prima facie case, the documents are to be supported. So once the documents of the plaintiff is marked, then the plaintiff is subjected to cross-examination. This is the stage where the plaintiff will be cross-examined by the counsel for the defendant, stating that the alleged substantiated documents are intact, whether the plaintiff is really eligible for a claim as prayed for. The defendant counsel would always try to disprove the documents filed by the plaintiff and to ensure that the plaintiff has no claim whatsoever. Whereas, once this particular stage of cross-examination of the plaintiff is over, the plaintiff has got the liberty to furnish more witnesses to substantiate his claim, in addition to the deposition of the self, which is the PW1. If there are further witnesses, the plaintiff is expected to furnish further witnesses to support his claim additionally. Once the additional witnesses are examined, they also follow the same procedure of cross-examination. Once the stage of plaintiff side evidence is closed, then the next stage would be the stage of the defendant, which is called defense side open. Now the defendant is expected to furnish a proof affidavit in order to defend the status quo of the plaintiff by substantiating certain evidences to disprove the claim of the plaintiff. Here what happens is, it's a double-ended sword. The cross-examination again begins. Now the plaintiff counsel cross-examines the defendant to claim that the the prayer of the plaintiff is to be decreed for, and the material evidences produced by the defendant, if so any, are to be disproved by the plaintiff counsel. The defendant counsel would also, in the stage of the plaintiff being cross-examined, the defendant counsel also can produce certain documents which are shown to the plaintiff, acknowledged by the plaintiff, if so, would be also marked as part of the plaint documents. Once the stage of evidence is closed, again the defense side evidence has the liberty to furnish further defenses, and if there are no witnesses any, then the defense side closes. Once this stage of evidence closes, then the case is next posted to arguments. In the arguments, there are two stages. One is written arguments and then oral arguments. This written arguments is a very mandatory and very significant step, so that what is the claim of the plaintiff is to be reduced in writing, so that this forms as part of a court record. Once the written arguments are over, then the plaintiff has the liberty to orally argue the matter, convince the court in such a manner that the plaintiff has a real valid claim, and that is to be decreed for. He can also produce citations from the apex courts or from the appellate courts to mention that the claim is has a precedent wherein this particular court has already allowed this kind of a similar petition, which will add more value to the case of the plaintiff. Once the oral arguments are over, from the side of the defendants, they have the liberty of filing the written arguments and the oral arguments in the similar manner that was explained earlier. Once the stage of judgment, the arguments are over, then the next stage is the final stage, which is called as a pronouncing of judgment. The court, after perusing both the records from the plaintiff as well as the defendant, from the statements produced by the witnesses and from the arguments adduced by the counsels respectively, has the liberty to pronounce the judgment, which could be in favor of the plaintiff or which could be unfavorable to the plaintiff as well. So the civil suit proceedings has got these stages, which will all corroborate to form the hierarchy of a civil stage suit. So with that, we have come to a holistic understanding of what a civil stage suit undergoes. We will still explain you stage by stage, intrinsically, to further elaborate each stages in a more comprehensive manner in the upcoming videos. All the best for your future careers. Thank you.